Education and the issues raised, including jurisdiction and forum shopping. Thank you. Senior Counsel, we want to manage time. How long do you want to be? We are dealing with an
give me 20 minutes, and my colleague, Mr. Macharia, here 5 or 10 minutes. 30 minutes we should be done. Yes. Thank you.
Mr. Correspondent, take 30 minutes. How many minutes do you want to share?
My Lord, we are not saying the same thing. We are merely all respondents. I believe equality of arms states that we are given a similar amount of time.
Both.
So you want 30 minutes?
Each.
Mr. Wanyama, 30 minutes?
No. 30 minutes per respondent.
In that case, there is no equality of arms.
What kind of equality of arms?
My Lord, the choice of respondents is theirs. We are here at their invitation.
Yeah, but we have to manage our time. That's why I'm really putting it so that we negotiate, and I think once we start, we start.
My Lord, I think what he's saying is the 30 minutes per respondent. That is the equality of arms. There are 3 respondents.
That's the economy.
90.
Yeah, 90. But maybe it could take less. We never know. But 30 minutes allocation will be better per respondent.
1925.
Per respondent?
Yes.
Most of it.
I think that's a fair one.
I don't want you to say you push me to the wall.
Thank you.
We will manage where we think we are fitting the policy and system.
Okay.
That's acceptable?
That's acceptable.
My Lord, I ask this honorable court to appreciate that in the impeachment of a president or the deputy president of Kenya, constitutionally, is in 2 stages or 2 phases. The first phase or stage being the National Assembly, and when it does what it is supposed to do, my Lord, then the matter goes to the second stage, second phase of impeachment in the Senate. So that, my Lord, my submission here is that without any doubt whatsoever, the resolution of the National Assembly crystallized the ripeness for this court's intervention to do justice to this very weighty matter of impeachment of the deputy president, the first time in the history of the country. My Lord, your Lordship has jurisdiction. And my Lord, when the people of Kenya by nearly 70% enacted the 2010 Constitution, they specifically conferred on this honorable court jurisdiction to hear and determine whether anything said to have been done pursuant to this constitution or the law was in fact done in accordance with the constitution of the law. That jurisdiction was conferred on your lordship by the people of Kenya. And my lord, the constitution, like the Bible, this constitution is what holds our nation together. So when your lordship is interpreting this constitution, applying this constitution, your lordship is assisting this nation to continue holding together. It is the constitution, it is the rule of law, it is constitutionalism that holds us together. And my lord, let me start very briefly by referring this honorable court to Article 23 of the Constitution, the heading of which is authority of courts to uphold and enforce the Bill of Rights. This is what the people of Kenya said. They conferred on the High Court that authority. My lord, when you look at Sub-Article 1, it says that the High Court has jurisdiction in accordance with Article 165 to hear and determine applications for redress of a denial, violation, or infringement, or a threat to violation. My lord, we are saying our rights have been, constitutional rights have been violated, and it's only your lordship that can stop further violation on a momentous issue of impeachment of the deputy president. My lord, Sub-Article 3 B gives this honorable court jurisdiction to grant an injunction, and C grants this honorable court jurisdiction to grant a conservatory order. Nothing could be clearer in black and white in the Constitution itself. So that, my lord, when this court considers authorities that you be cited by both sides, my lord, I submit that this court should bear in mind that our transformative constitution has provided the jurisdiction of this honorable court, so that this honorable court cannot just factor in decisions from the US, decisions from UK, and decisions from elsewhere, unless it is demonstrated that the constitutions in those countries are in pari materia with our constitution. In other words, the starting point is our constitution. Article 2, which your lordship is aware of, provides for the supremacy of the constitution and proceeds to say, to provide any other law or any other provision in conflict with the constitution is null and void to the extent of the inconsistency. So that, my lord, under Article 25C, Article 25C, the heading of which is fundamental rights and freedoms that may not be limited. One of those rights is the right to a fair trial. That cannot be limited. The people of Kenya thought the right to a fair trial is so fundamental that they said it is not to be limited. What I'm driving to, my Lord, is Article 50, the right to a fair trial. Sub-Article 1 says before a court, or if appropriate, another independent and impartial tribunal or another body. My Lord, it is our submission that the National Assembly, exercising quasi-judicial authority, is constitutionally obligated to ensure a fair trial to the petitioner. And that is a right that cannot be in any manner abridged or limited. My Lord, we say in our notice of motion and in the petition, one, that the public participation which is required in terms of Article 118 of the Constitution was grossly violated by the National Assembly. My Lord, let me draw the court's attention to Article 118, the heading of which is Public Access and Participation. And B, Sub-Article 1B, says, Parliament shall facilitate public participation. So it's a requirement of the Constitution. An involvement in the legislative and other business of Parliament, other business such as the impeachment of the Deputy President. So, my Lord, if the petitioner is alleging that this public participation, constitutional obligation of the National Assembly was violated, this court has, without any shadow of doubt, the jurisdiction to intervene. My Lord, it is our submission that public participation in this very weighty matter of impeachment of the Deputy President was in this case a sham. It was a show. Totally inadequate in terms of time. The Supreme Court gave guidelines in the British American Tobacco versus the Ministry of Health, and this is in our Bible of Authorities, that public participation must be real. It must have reasonable time. It must be meaningful. Lord, it is on that basis that we are submitting and will be arguing that the 12 days that Standing Order number 64 provided for the entire process of the impeachment in the National Assembly violates Article 50 of the Constitution. The National Assembly had no constitutional authority to limit themselves to only 12 days. That that resulted in inadequate public participation on such a weighty matter. My Lord, you will see that first the National Assembly directed that the public participation would be at county headquarters of our 47 counties. The question arises, are the people in any particular county to travel all the way to the county headquarters, one place, to publicly participate, give their views on such a weighty matter? That was on the 4th of October. Lord, when your brother in Kerugoya Court directed that public participation should be at the constituency level, a further notice was issued by Speaker of the National Assembly correctly saying the public participation will be at the constituency level as directed by your brother, Judge in Kerugoya. But that notice, my Lord, was issued on the evening of 4th October. That civic education will be the following day. Where is the time for the people of Kenya to be made aware that there will be public participation the following day? So the public participation, quote and unquote, at the constituency level was on the very date that they had about this further directive by the Speaker. So, my Lord, without going into the details, because you do that during the actual hearing, my Lord, is it any wonder that only 200 and what? The number. My Lord, in volume 2, I think we gave copies to the court. Could you give this to the court here? Page 812. Page 812. The court has the soft copy, but this is a hard copy. If my Lord looks at page 812, you can hand over this. You can hand over this to the court. 812. My Lord has, yeah, hand over. Yeah. Yeah. It is labeled RG11 at the top. Sir, my Lord. Yes, it did. Who is the owner of it?
He said. No, I want him to be sure.
Keep it safe, it's okay. Page 812 is actually RG11 in volume 2. If my Lord looks at page 812, left hand corner at the bottom, volume 2. This is volume 2. RG11. but go to 812 of RG 11, bottom left-hand corner. My Lord, do you see the total number of people who took part in this public participation is 224,907. My Lord, out of over 50 million Kenyans who have attained the age of 18, because of the shortness of the notice, only 224,907 were able to participate. But no, that is dismal. That is not public participation. And Article 118 And Lord, Article 118 requires Parliament to facilitate public participation. The Supreme Court has said the notice must be reasonable, must be adequate, the public participation must be meaningful, not a show. My Lord, 224 or 225, even if you are to leave aside the 50 million Kenyans who are above the age of 18, even the registered voters are 14 million. This is demonstration of the fallacy, of the mockery of the public participation. And my Lord, on the same RG 11, RG 11 at page 790. Page 790 is volume 2 again. Page 790. My Lord, at the top of page 790, my Lord, do you see the constituency there, 95, Keyo South? My Lord, if you go to the column showing support, it shows 162.79% support. My Lord, what could demonstrate 162.79 support? In other words, apparent there of all the registered voters shot through the support to 100, even if all the people who turned up for the public participation said yes. How does the figure go to 162.79, actually virtually 163%? My Lord, is this data on which this court should allow that resolution to proceed for the impeachment of the deputy governor? And my Lord, yes, my Lord. Yes.
In that constituency, I don't know if these figures in fact, the total 33.
There?
Yes.
There is 70.
Yes.
And then I do not support.
3.
And then that would be how many?
I'm just pointing out,
Yes.
because they tell us the total number who turned up were 43. Then how come 70% supported, if the total number?
That column is the same as the column we were, the grand total. You go to grand total.
Yes, the grand total
Page
appears in
812.
column 2, yes. Where the
It's the same column.
202nd column. List the constituencies. But
So at page 812,
8, yes.
at the top, that is it's a called columns and not rows. The column shows total responses, right?
Yes,
And this is per constituency,
yes.
and the national tally is at 224. Correct?
That is correct.
Now the same.
Yes.
Then in the case of KO, I would assume the total of those who turned out are 43.
That's what we were told.
And then those who support are 70.
Yes, contradiction.
And then 3 do not support. So that takes us to 100, over 100.
Yes.
Okay, proceed.
Follows the other submission also in here. The petitioner, who is the subject matter of impeachment, should have been accorded an opportunity to answer to the allegations, so that the allegations and the petitioner's response are then taken to Kenyans in the public participation. For them to be able to make an informed decision. Only the allegations were taken, not the response of the petitioner. Is this public participation as envisaged in Article 118 of the Constitution? The answer has to be a resounding no. Lord, there was no adequate time when this data was returned to Parliament. We don't have how it was evaluated, because the purpose of public participation is that the views of Kenyans are taken into account when the National Assembly is then debating and passing a resolution. And then, can I have no, the data. The data. Yeah. My Lord, the public is denied the evaluation by the National Assembly of the data that was collected. If you go to page 813 of volume 2, 813, 813 at the bottom. The independent, credible pollsters shows, number one there, that only 2,236, 7% voted in favor of impeachment of the petitioner applicant. Sorry, my Lord. The opinion polls, they conduct online opinion polls And when the figures in Parliament are saying the opposite, this independent pollster shows only 7% was supporting the impeachment of the Deputy President. Double that number, 14%, 4,433, supported the impeachment of the President, although it wasn't part of the questionnaire. And 75% of the Kenyan people, 24,122, said the President and his deputy should be impeached together. So the overwhelming majority in this limited public participation voted in favor of both being impeached, but 93% were against the impeachment of the Deputy President. My Lord, My Lord, in our list of Battle of Authorities, at page 36, my Lord, you see the case, the Supreme Court case of Peter Gatira Omunya, and the passage I want to draw the court's attention to appears at page 52. Paragraph 97. Yes, 97 of the decision. 97. If you permit me very quickly, bearing in mind the nature of the competing claims against the background of the public cause, we have focused our perception on the public interest and the concept of good governance that runs in tandem with the conscious deployment of scarce resources drawn from the public, proper husbandry of our public monetary and other resources. We take judicial notice in a major challenge to all active institutional and processes of governance and the court by the established attributes. Line drawing must ever have interest in contributing to the resources. And at paragraph 86, perhaps I should have started with it, the Supreme Court says conservatory orders bear a more decided public law connotation. For these are orders to facilitate ordered functioning within public agencies, as well as to uphold the adjudicatory authority of the court in the public interest. Conservatory orders, therefore, are not, unlike interlocutory injunctions, linked to such private party issues as the prospect of irreparable harm occurring during the pendency of a case or the high probability of that success. In the African case, conservatory orders, consequently, should be granted on the inherent merit of a case, bearing in mind the public interest, the constitutional values, and the proportionate magnitude and priority levels attributable to the relevant cases. My Lord, on the very day that My Lord, on the very day that the National Assembly concluded debate on these unsatisfactory results, at 9 p.m. at night, they passed a resolution. That resolution was transmitted at night to the Senate. And the Senate has issued its timelines, and we have annexed the timetable to the supplementary affidavit. You will see the Senate's timelines at page 13, saying they will deal with the impeachment on Wednesday, the day after tomorrow, Wednesday and Thursday. So, my Lord, we plead that you grant us a stay of that resolution, a stay of the impeachment in the Senate, to accord time to this court to hear these very weighty constitutional issues, preserve the substrata of the petitioner's case. Because, my Lord, when you look at the speed with which this matter is being moved by whoever is controlling the levers, by Thursday, when the Senate concludes, if they conclude to remove the Deputy President, my Lord, within the hour of their doing that, it is our submission that one can expect a Deputy President will have been appointed. The entire substratum, the subject matter, will become moot, will become academic. The petition and this notice of motion will be rendered, you have been rendered nugatory. This court has to stamp its authority in favor of constitutionalism, in favor of the rule of law. My Lord, we are at crossroads. We either go back to the imperial presidency, where the constitution is replaced by the wishes of whoever is the president, or we go back onto the rails where we are nation governed by the constitution and the rule of law. So, my Lord, it is my plea that your Lordship stands up for the nation, that your Lordship refuses to be intimidated in any way. My Lord, we've seen some of your colleagues whose security have been withdrawn, some allowances of judges being taxed, my Lord, the budget of the judiciary being reduced. My Lord, stand up against this. Don't allow any of this to interfere with your functions as a judge of this High Court. My Lord, because I don't want to take time, I draw your court's attention, your Lordship's attention, to the decision in the case of Joseph Enoch Aura versus others. You find it at page 219 of our Bible of Authorities. Joseph Enoch Aura, page 219. in our battle of authorities. And at page 223, paragraph 5 of the decision, you will see your brother judges, Mavea, and there were 3 judge bench in that case, giving the minimum conditions for effective.
Did you say paragraph 5?
Paragraph 5 at the top. Paragraph 5 at the top, page 223.
What is the paragraph of the decision?
It is paragraph 5 of the decision. It is to be found at page 223. My Lord, the conditions are there, minimum. Proper sensitization on the nature of the legislation to adequate notice. 3, facilitation of the public. The views of the public should be considered, and where they were to be rejected or declined, the reason for such rejection or dismissal. Public participation should be inclusive, should reflect a fair representation and diversity of the populace. There must be integrity and transparency of the process. None of this was observed in the public participation, quote and unquote, that was conducted in this case. My Lord, the only way to promote and preserve constitutionalism and the rule of law is to grant us a limited stay. Your brother, the Honorable Justice Mugambi, actually certified there are very weighty issues in those other cases. And they are. The new dimension has been brought in this case by the passage of the resolution. But the issues remain weighty. Preserve the position, at least to give time for that 3-judge bench, perhaps to include this case, alternatively to give this court time to hear full arguments on the violations, including the constitutional validity of Standing Order number 64. And as I sit down, my Lord, let me mention that this requirement for public participation acquires added significance in a presidential system of government. That requires we no longer have any confidence in you as a president or deputy president, but gross violations of the law, not just violations of the Constitution, but gross violations of the law or other law. My Lord, the word gross is to be interpreted as justem generis. Violations of those other laws have to be gross. Why? Because it's a person that millions of Kenyans elected. In the particular case of the petitioner here, over 7 million Kenyans voted for him. So it's not an issue of we don't have confidence in you. It's not an issue of we don't like you. It's you must satisfy the requirement of gross violation of the law. I'm merely saying preserve this situation until we are able to argue these matters. I hand over to my colleague, Tomacharya. I thank you, my Lord.
My Lord, just to note that my colleagues have taken 41 minutes.
I'll be very brief, my Lord. I rise to make only 3 points. In response, my job is to carry Mr. Muite's books. I'll be very quick now. In summary, my Lord, stripped to its bare essentials, what my learned colleagues for the respondents will be telling you shortly is that this honorable court has no jurisdiction on three primary limbs. They will tell you that the doctrine of separation of powers precludes you. They will tell you, secondly, that the dispute before you is not ripe. They will tell you, thirdly, that the matter is sub judice and should therefore not be heard for you. They will cite for you, my lord, an authority listed in the, I believe, grounds of opposition of my good and learned friend, Mr. Kuyoni Josephat, for the Attorney General. This is the case of Muite and another one,